Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. Hospice Audit Series. Welcome to the party. Contractor participation at ALJ hearings. Well, Bryan, Zaina, Emily, this is a very fun topic, and in terms of new developments, I think for many years, hospices and we were used to showing up to hearings, and it's us and the judge. And a recent trend has been that's not so much the case anymore. And Zaina, why don't you kick it off here? What has been our recent experience?
We are seeing an uptick in contractor participation in administrative law judge hearings. So as many of our dedicated listeners know, hospices go through an appeal process that eventually involves a hearing before an ALJ. And once an ALJ is assigned, the government contractors involved are given the opportunity to appear at the ALJ hearing. And typically those contractors don't appear, and the hospice, through an expert physician, ends up being the only party to provide testimony at the hearing. But lately, the new development is that we're seeing certain contractors appearing more frequently at ALJ hearings. And there's two different ways that a contractor can elect to be involved at the ALJ hearing stage.
Well, let me pause you there a second. One may be thinking, why is this a recent trend? Because I think several years ago, I feel like CMS put out a memo saying, hey, contractors, you should be showing up to these hearings that you're denying claims for. And then I think we saw a little bit of participation, but I think in the last 6 months, we have been seeing an uptick in that, and I'm not exactly sure why, but just to interject there. And so, the common way we're seeing people participate is through this participant in contrast to party status, which I think is really important. And I know you're going there, Zaina. So why don't you explain for listeners the difference between participant and party? Because sometimes I think the government might not even understand necessarily the difference, because they have said, hey, I want to be a party. And then we're going to talk about this. We issue discovery, and then it's like, oh, wait, I don't want to be a party. I just want to participate. And so let's talk about what a participant is and what does that allow us to do or not do at a hearing.
Sure. So a participant is going to be somewhat less involved than a party. As a participant, the contractors are able to file position papers if they do so 5 days before the hearing. They're also allowed to provide testimony to clarify different factual issues, but they're not allowed to cross-examine the hospice's physician, and they can't be cross-examined by the hospice's counsel. The ALJ can ask the contractor participant questions about their testimony, and they can answer. But as I mentioned, there's no cross-examination from either side.
Yeah. So Emily, let's just turn to you. How has that played out for you in hearings? Because well said, Zaina, about the limits of that. I mean, are those guardrails really followed by the ALJ in terms of putting them in their right lane?
I would say that the guidelines are typically followed, but I have had instances where the administrative law judge will ask the participant from the contractor whether they have any questions that they would like the ALJ to ask of the hospice's witnesses. But at the same time, even though we're not allowed to cross-examine them, we are usually given the opportunity to have our expert rebut anything that was said by the contractor's participant.
So I'm envisioning that this is sort of, well, we're not directly speaking to each other, like the ALJ is the intermediary and we can sort of ask questions through him or her. Is that a right depiction?
That's exactly right. Yeah.
Okay. So, and I guess, and maybe Bryan, this is for you. You've been at this a really long time, and I remember an ALJ hearing we had a lot of years ago, and we had a physician for the government appear. And I guess, how much do you need to be on your toes, and how much do you push back if you see that they're not, abiding by the guardrails? I mean, do you let it go? Do you push back? I mean, and this is probably all the reason why you need to have counsel that can help you make decisions and maybe not go alone.
Yeah, I think that's right, because the decision on whether to push back and how to push back, it really is something that you have to do on the fly, because you don't get a lot of advance notice about what these contractor participants are going to say. And sometimes we like the flexibility that the ALJ imposes, because I've had contractors appear as participants, and yet the ALJ allow me to question them directly. So we won't complain about that. And sometimes these contractor participants, I've also had it be the case that they will, in their comments, concede certain claims, and we don't want to stop them from doing that. But otherwise, if it gets to the point where the contractor is really trying to address the hospice provider directly or the expert physician directly, I typically try to push back and remind the ALJ that, hey, they're just a participant here. This should all be all of their comments should be directed to you. And that's a way to either put them back on their heels or slow down momentum they've gained. But it is really a judgment call that you make. And our team of attorneys who have been on these calls know how to manage those to the best advantage of the hospice. So sometimes we want to enforce those guardrails, sometimes not so much.
So participant, I think, is the most common thing we are seeing, and but recently, the government has given notice that they're going to show up as a party. And maybe that's first saying, Zaina, this is for you. When we say government showing up, who is that? Who's showing up?
We're talking about any government contractor or representative of a government contractor. So whether it's a qualified independent contractor, Medicare administrative contractor, or any other variation of the government agencies that participate in these hospice audits throughout the appeal process.
So who is most often showing up? Let's say I had a UPIC audit. Is it that original UPIC contractor, or is it the latest person to review the claims?
Yeah, so I think it depends on your jurisdiction. So for example, if you're in a CGS jurisdiction, they're a Medicare administrative contractor, and they often show up. Relatively often. They more frequently show up than the other MACs like Palmetto or NGS, and they have a physician who shows up who is quite experienced in these hearings. So if you're in a CGS jurisdiction, that might be the most likely other side to show up. And more recently, what we've seen is increased participation by the QUICs, and that's C2C or Maximus, appearing with attorneys in some instances, with physicians. Maybe it's just a nurse reviewer on her own, but Maximus and C2C have really stepped up their appearances as parties, at least initially in these cases.
So, Emily, how does this play out with what it means to be a party, and what have we done, and how has that sort of ended up at the close of the day?
Well, the distinction between a participant and party is significant, and you may not realize that because the terms are so similar and they can sometimes be used interchangeably. As you mentioned, Meg, the government may not even know the significance of the difference between the two. But when the contractor elects to be a party, they're given the right to actually put forth evidence at the hearing in the form of testimony. And that includes testimony about the records or other facts. and also provide medical opinion testimony, whereas as a participant, that's not necessarily the case. As a party, they're also able to cross-examine the hospice's witnesses. But I think the biggest thing to be aware of is that as a party, they have a right to appeal a favorable decision that's issued to the hospice or the provider. And so that's a very important thing to keep in mind when you get a notice. It's one form, and you got to pay attention to whether the contractor has marked that they are going to be a participant or a party.
Yeah, well, so important. You don't want to get your P's screwed up, I guess, as a Meg Pekarske, right? So you don't want to get your P's screwed up. So because being a party could completely change the tenor of that hearing. But I think there's also opportunities for us when the government is a party, and that's about taking discovery. And Bryan and Zaina, I don't know if you want to jump in there about what has been the process of taking discovery. I know sometimes we have asked for discovery and then it's like, wait, I don't want to be a party anymore. I want to be a participant. But how has that played out?
Sure. So, as you mentioned, Meg, providers are given more rights when a contractor elects to participate as a party. And the main right there is we can request production of documents. So to initiate discovery, it's a pretty straightforward process. The hospice just has to provide notice to the contractors and the ALJ. And the discovery has to be relevant, not privileged, and not unreasonable or unduly burdensome. So the ALJ has a lot of discretion here. They will consider the request, and the ALJ can either permit or deny it. Sometimes that involves the parties getting together for a pre-hearing conference to explain the discovery issues. And in some cases, when we've initiated discovery, we've seen the contractors back down and withdraw their notice of participation. So in some cases, that's been right after we have requested to take discovery. And in other cases, we've gotten partway through the discovery process and gone back to the contractor and said, hey, we noticed some things are missing, and they've withdrawn at that point.
Interesting. So Bryan, what kinds of things have we asked for in discovery, and what have we gotten?
Yeah, and well, as far as what we've asked for, it seems that everybody is a bit surprised that there's discovery, and that includes the ALJ, that includes the contractors. When we issue discovery, which is explicitly allowed in the regulations, it seems we encounter a lot of head scratching, like, why are you guys doing this, and what are you doing? But it is allowed, and I think it is a burden on these contractors that they would rather do without. And so we really try to target our discovery around the relevance standard that Zaina described. So we're looking for credentials of any testifying witness. We want to obtain materials they plan to use at the hearing, any kind of evidence they intend to submit. We try to get communications they have had regarding the particular audit or claims at issue, so we can see if these contractors have been communicating with other contractors or with CMS about that, and even internal communications. Another important category of documents or information we try to get is their training and education materials, anything that they rely on in forming their testimony, to see, are they really applying hospice principles as CMS has defined them, as hospice physicians understand them, or is a lot of their understanding of the hospice benefit, perhaps derived from some flawed materials, and we can try to point that out to undermine their credibility.
Well said, Bryan. You're such a professional podcaster with your very thorough explanation, but I'm going to give Emily the last word here as we wrap up. Have you run into any fireworks or what has happened that's interesting in this regard? I mean, have we gotten anything really fascinating? Are the credentials of folks impressive that are showing up on the other side, having extensive experience? Like, how has this played out in real life?
Well, we've certainly had cases where the credentials reveal that the person pegged to testify did not have any hospice experience. And that's been very helpful to us in these types of cases because, as you know, or as our listeners should know too, that the hospice benefit is unique and that it requires that a physician prognosticate a patient's life expectancy, a physician specifically. And sometimes it's a nurse that comes to testify and the nurse doesn't have any hospice experience. And so we've learned that through this process. And at other times, I'll just echo what Bryan has said, that everybody seems very surprised that we are doing these discovery requests, and they don't understand why, because perhaps they're not as familiar with the hearing regulations as we'd hope they'd be.
Yeah, well, and maybe I'll give myself the last word here, but I think that this sounds complicated, more complicated than, quote, the olden days. And so I don't know that folks need to be worried if I have single ADR TPE claims that I need to worry that the government's going to show up and I need to absolutely have a lawyer. But I think when we're talking about the cases we're more often seeing, which is large CPI, sometimes people call them SMRC audits, but we call them CPI audits, UPICs, other things like that, where you have a number of claims, there's just going to be more likely the government's going to show up. And I think there's a potential that it's going to get treated more like real litigation than less. And so I think that's where having legal counsel can really be helpful. And we've gotten involved in some cases recently where we didn't do the workup to the ALJ hearing, but we're getting involved now because they just felt that they weren't getting as much movement, and the government was showing up on the other side, and that was rattling. And so I think all this being said, an observation I have is, I think the need for legal counsel at hearings is maybe the balance is shifting, especially if you have multi-claim appeals, or with CPI audits, you can be, $1 million can be at stake. So I think, keep track of the P's from the get-go, because I think what I learned here talking to all of you is just, it can be easily overlooked, and sometimes you don't get a whole lot of notice, and you might need to change your game plan. But Bryan, I'm going to give you the last word because, you're my partner here. So do you want to give it one shot over the bow here of your brilliance you can add to the closing of this?
Well, that's quite a setup, Meg. I hope not to disappoint. But I think it is, be mindful when you hear or get notice that these contractors are going to be there. Pay attention to the P's. It does affect another P, which is preparation. So
Ooh,
it's going
nice.
to, yeah, you like that? There we go.
I like it. Triple
and
P's.
So it'll affect how you prepare your witness and how you, as an advocate, if you have counsel, if you have one of our team members on there, we know how to work with and handle these situations. But if you're going it alone, it just requires a whole new set of preparation about how do you push back against what the other side is doing. Get ready to cross-examine them. Get your own witness ready to be cross-examined. There's a lot of skills and things to learn about that we do routinely, but preparation is going to be considerably affected.
That is fabulous, Bryan. Isn't that called alliteration, where you have you used to be about the E's, excellence, efficiency, effectiveness. Now you're about the P's, party, participant, preparation. So fabulous. Perfection. There is no such thing, Bryan, as perfection.
We strive for it.
We strive for it. We strive for it. But, well, fascinating development. Thanks for sharing your knowledge, Zaina, Emily, and Bryan. Really wonderful discussion. And
Thanks, Meg.
until next time. Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.